We are going to get going with the first panel now. If I could ask everyone to take their seats.
We're going to resume now, so if you could take your seats, please, I'd appreciate it.
I feel sort of bad because I promised everyone dessert and it hasn't arrived, but it will. So our first panel is called Embracing Change, and it's going to be addressing the changes that we're facing currently and also what it takes to adapt. This panel is going to be moderated by Jennifer Griffiths. Jennifer has been a partner since 2008. She is the co-chair of the Catastrophic Practice Group, the EUO Practice Group, and the WSIAT Practice Group. And of course, her busy practice also includes priority and loss transfer disputes. Jennifer is also in charge of all of our internal education at ZTGH. And if you have seen any of our road shows that has to do anything remotely to do with accident benefits, it was either likely produced by Jennifer or at least prodded along by her. On the panel, we have two members from ZTGH who I think everyone knows. David Zarek. David practices mainly in the areas of tort, motor vehicle accidents, special investigations, product liability, and commercial liability claims. He is the co-chair of our coverage practice group, but David's real specialty is the messy, complicated files, and his skill is really seeing his way through the files and connecting all of the dots. David has appeared before all levels of court, up to and including the Supreme Court of Canada. He has been selected by his peers for inclusion in Best Lawyers in Canada in 2017 in the areas of insurance law and personal injury litigation. Eric Grossman is Certified Specialist in Civil Litigation by the Law Society of Upper Canada. He is part of an exclusive group of lawyers who can say they were successful at the Supreme Court of Canada. He is regularly retained on appeal matters. He has been retained as an expert witness in the area of statutory accident benefits on a number of occasions. Eric has been on several advisory committees with respect to changes to the statutory accident benefit schedule and proceedings, although he maintains that we cannot blame him for anything we don't like. Eric was selected by his peers for inclusion in Best Lawyers in Canada and again in the areas of insurance defense and personal injury litigation. I'm very pleased to introduce our guest panelists, and I thank them from the outset for coming today. Jasmine Daya is from Fireman Steinmetz Daya. Jasmine is the managing partner there and also heads the accident benefits department of her firm. Jasmine has a Master of Law from Osgoode Hall Law School and a certificate from Harvard Law in negotiation. In addition to an incredibly busy practice, Jasmine is committed to giving back to the legal community and the community at large. She volunteers as duty counsel at the Toronto Courthouse for Pro Bono Law Ontario. She's a guest lecturer for the insurance law course at Queen's University. She has served as a mentor for the Toronto Lawyers Association, and she's also been a speaker at various conferences, whether it be the Ontario Trial Lawyers Association, the Bishop Strachan School, or the Faculty of Law at Queen's University. From experience, I know Jasmine is a tough but practical lawyer. She is apparently one of the few people in this world who has been able to find that 25th hour in every day because she's incredibly busy. I'm not sure how she manages it all, but I'm very thankful that she's found the time to be here with us today. We're also very privileged to have Richard Shekter from Shekter Dichtenberg here. Richard is one of Ontario's leading litigators, not just in personal injury litigation, but also professional discipline, wrongful dismissal, and criminal law. He is general counsel to the College of Massage Therapists of Ontario and the College of Dental Technologists of Ontario. Richard has long been a precedent-setting lawyer in an incredible array of cases. In Regina and Pinnacle Transport, he received what at the time was the second largest cost award against the Crown. In a fraudulent conveyances trial, he obtained a punitive damages award in what was one of the biggest at the time. In Rothstein and Smith, in a states dispute, he went all the way to the Supreme Court of Canada and won costs that remain one of the largest ever awarded in a state's case. And hopefully everyone can start to see the pattern here. Most of you will know Richard as the lawyer who has won precedent-setting personal injury awards. When he won in Roberts and Marana, that verdict was at the time, guess what? One of the largest personal injury awards ever recovered in Canada. I asked some of my partners about Richard, and they described him as a lawyer's lawyer. They said he was an amazingly smart and creative lawyer. We're very fortunate to have him here to provide us with the insights that he brings with such diverse experience. Before I hand the microphone over to Jennifer, if you have any questions for the panel as we go along, if you could ask your lawyer to email her, she will try to put the questions to the panel if she can fit them in. And so I encourage you to, I was going to say bombard, but that's cruel. But I encourage you to participate in that manner if you have anything you want the panel to address. So, Jennifer?
Thank you, Heather. I think we have one slide here, do we? How do I do this? Did it disappear on me? There it is. So I actually only wanted to do this panel because it allows me an opportunity to show you some of my favorite public art in the city. I don't know, does anyone know where that is? Yeah, so it's the Queen Street Viaduct, and the wording across the top of the bridge, "This river I step in is not the river I stand in," and this is actually on my commute home. And a great reminder that the only constant in life is change, and how well we fare in life is how well we adapt to that change and thrive through it. So this is the Pollyanna.
I didn't recognize the picture because today it's underwater.
Which is a segue to thank you, all of you, for the third time or maybe the fourth time today for braving potential deluges to be here with us. We really appreciate it, especially those people who may be reliant on the DVP or the northbound GO train later today. So we had a couple of interesting chats together before today, and one of the first things we started talking about as we were thinking about change was just what are the biggest changes that we have experienced in our practices over time, and the answers were varied and interesting. So I think I'm going to start, Richard, with you. The biggest change that you've seen since you started practicing.
Well, first, Jennifer, I want to thank you all for having Jasmine and I in a room full of insurance people. I can't tell you how happy I am. I have never been more excited. And I should tell you, I felt very comfortable. So, I actually made a list. I got here and I realized that when I started practicing, there was no such thing as accident benefits. There was no such thing as referral fees. Advertising was illegal. This is not a joke. There were no contingency fees. There were no computers. There were no word processors. And when you hear what I'm saying, and if you want to consider just how seriously you should take it, I want you to think about two things that will demonstrate to you that I probably shouldn't be here. The first is that when I had a firm called Levitt, Shekter and Schnurr, a fellow came in, a salesman, and he said, "I'm selling you a fax machine. It's great technology." And I turned to my partner and said, "Telex is the way to go for the future." The second true story, McMaster University, I put on a play called How to Succeed in Business. I was the director. I put a kid in the chorus who tried out for the lead, Martin Short. So, having said that, the biggest thing that I see is that I grew up in an era where guys like Eric and David were opposing me all the time. And if you had a real case and you thought it was settleable, you could sit down with these guys and you'd settle it. And if there was a disagreement, it wasn't because they were bluffing and you were bluffing. It was because you had a fundamentally different view of the same set of facts for legitimate reasons, and you had to try the case, and you did. And so I grew up in an era where the people that I were opposing were experienced trial counsel. And what's also dramatically different in this, and I can see it in this room, is that opposing counsel were invariably male. There was virtually no one in the bar that was female who was in the personal injury litigation bar, or frankly in any of the litigation bars. So those are the two most profound changes. Some of the best lawyers in this province are now women, and I'm coming up against the jury trial or the trial itself. The people that I'm coming up against, for the most part, have not had a trial. And I know this because we have a thing called computers. You may have heard about it. I just found out about it last week. But I go online and I check people out, and I can't find any cases. And that's probably the most profound, and that has implications for things that we're going to talk about later on.
Eric, how about you?
So I'm a couple of weeks younger than Richard. But when I started out, there also weren't really computers to speak of. You had word processors. But typically when I went to generate a step on a file, I would pull out my trusty dictaphone and dictate a letter or what have you. I would send it off to get transcribed. It might come back, if I was lucky, within a week. Sometimes it would take longer. It could take 2 weeks. If I was really lucky, or if it was urgent, it might get back to me in a day or two. It would then get sent out by letter post and arrive 2, 3, 4 days later, sit in someone's mail pile. They would then, in order to respond, apply the same approach to responding, and you would move the goalposts a yard at a time every month. Now, what we do is send an email instantaneously, and the touches that would happen every month to move the file along are now happening 6 times in 6 minutes. Because I'll send an email, and Richard will respond a minute later, and I'll respond to Richard. Or, God forbid, but we still might do this, pick up a phone and actually talk to each other. That is now not the norm, but that was the norm before. You're moving files that much faster. Everyone has the ability to do things that much faster. It's that much more efficient and speedy, and the expectations are that much more on us to do that. So that is the biggest change that I can tell you about.
So I may double back to our other panelists on biggest change since you started practicing, but I think that the speed of sound comment, Eric, am I in the wrong place with the mic? Okay. Is a really natural jumping off point for the biggest change that we've seen in the last year, which is, of course, the LAT. And so I just wanted to open that up, maybe Jasmine, to you first. Love it or lose it?
Forget that, hate it. I absolutely hate it because, should I continue?
Please do.
Well, I don't know if we have enough time to list all the reasons why, but...
We don't.
Yeah.
Yeah.
Okay, well, I'll hit the highlights. The unilateral scheduling is a huge problem. Everyone agreed that Fisco, was taking too long with things, but then telling me that I have a hearing in a couple of months from now when I already have discoveries, pretrials, and other things scheduled is hugely problematic. The hybrid hearing, or the in-writing hearing, is also a problem. Getting my doctors to sign an affidavit has presented challenges. I had one occasion where I asked a family doctor to sign an affidavit. Well, actually, I asked an associate to do it because I was actually at a mediation, followed by discovery the next day, followed by all these other things because this hearing had just been stuck in my calendar. So I asked an associate to contact the doctor and explain to him that we needed him to complete an affidavit so we can get his evidence in at this in writing hearing. We then get a phone call from counsel who has been retained by the College of Physicians and Surgeons because the doctor felt that my office was putting pressure on him and he felt very stressed at the request to sign an affidavit. And I don't totally disagree, because we were stressed out ourselves because we had to get this in within a few days. But he had a busy practice and he said he was stressed, so he didn't know what else to do but seek guidance. This was made worse by the fact that counsel said, "You didn't even offer to pay him." And I said, "Pay him with what? I have nothing to pay him with." So the fact that we don't have any cost consequences is hugely problematic. That's only one little example. What about claims where there is no tort action? It's just accident benefits. How am I supposed to fund this? My clients don't have funds. I'm already not generally getting paid on these LAT proceedings at this point, more pro bono work, because there's no costs. So who's going to represent these people? That's one of the problems I've had. I'll tell one other problem. I had a surveillance report served that had about 70% of the report was about surveillance done on the internet research of my client, who had a really common name. And they found articles in newspapers about criminal activity that may or may not have been my client, Facebook posts that may or may not have been my client, Instagram posts that may or may not have been my client. None of this looking good for my client. But the fact is, it could never be verified if it was my client, because how am I supposed to examine the surveillance expert? This stuff is going in as evidence without even being authenticated as fact. It's just being admitted. So I brought a motion to exclude the surveillance evidence from the hearing, and I tried to exclude the 20% that showed my client maybe working, saying,
Maybe.
Fruit from the poisonous tree. This whole thing should be kicked out. Didn't work, but putting that aside, I did manage to get the 70% of the surveillance report that may or may not have been my client kicked out. Then I got a decision thinking, oh, this is my claim to fame here. I'm going to get a whole decision. It's going to say all these fantastic things about what I did at this hearing or this motion. And instead, the adjudicator said counsel consented, so they've removed the part of the report that I brought a motion for, and I was very upset because no, she did not consent. There was a lot of work that went into that. But there's a lot of problems. I've had issues with hearings itself where I had one really great argument about estoppel. I was so excited. This was great stuff. And I knew I had a problem when the adjudicator said, "What rule should I look at?" I was like, there's no rule. I presented case law, and then he said, well, there's only 2 cases. I'm like, you don't need 100 to make it right. And then when he summed it up and said, so let me get this straight, you're arguing this and this and this, and then I said, no. I haven't got the decision yet, but I'm not sure what it's going to say. Probably not in my favor, so lots of problems.
How about Eric from a defense perspective? Same issues?
Well,
Anything good?
I got to tell you, Jasmine, I don't know why you're so concerned about the surveillance and the online investigation. On these written hearings, you could just say that your client is somebody else, and no one would be able to prove otherwise because we won't know. I love these hearings over the phone. All of a sudden, Mr. Claimant, I'm going to present you as Mr. Claimant. You will be that much more articulate than the real claimant, and no one will know that you're not my claimant.
That'll make for a good cross.
I don't know whether I'd win with you or not, Richard, as my claimant, but I'd probably stand a better chance than if I put my real claimant on the phone. But that's the practical reality of what we're having at the LAT. And we heard a little bit this morning about some of the process problems. It's profoundly concerning that you've got non-lawyers as adjudicators who don't understand the first thing about the law. Equitable remedies, procedural fairness, natural justice are concepts that they may have had an hour or 2 of training on, but in terms of in the trenches dealing with the problems, they have none. No experience whatsoever, and they're just plain getting things wrong. And it applies both ways, and I suspect that it's going to apply much more disfavorably to insurers in the coming months, where very good plaintiff lawyers have been putting their nuts away for the winter, as you will, storing them aside, and when the summer comes, they're going to take those nuts out, and they are going to start pelting insurers with those nuts pretty hard around the head. And if the insurers have not had an opportunity or have not taken the opportunity to continue adjusting their files and see what's happened since their termination a year and a half ago, all of a sudden there's going to be a barrage of new reports and a case conference 10 days from now and a hearing 60 days from now, and the insurer has nothing current to respond to those reports. Unless procedural fairness is applied, insurers are going to be led to slaughter. It's going to be an unfair fight, and there will be blood on the streets. And then you won't have to worry, Jasmine, about not getting paid costs, because you will get oodles of money of claim costs, of claim paid, that you could take your contingency fee from and get paid.
Plus interest.
Plus interest.
So, Jasmine, do you agree in terms of the volumes that we're going to be seeing?
With the LAT?
Yeah.
Yeah. People are holding back on applying to the LAT right now. Everyone last year was submitting all their applications as soon as that deadline in April, my office included. I made sure every application with even one denial went through FISCO. And then if there were additional denials, we'll add it in later, we'll figure it out. But we wanted everything in FISCO. My understanding right now, in my office too, but more I've heard from other offices, I was kind of eager. I'm like, let's see what happens. I'm sure it can't be that bad. I was so wrong. I'm sure it'll be fair. Very wrong. So I put in my applications just, because I thought that was the right thing to do for my client. But a lot of people are holding back. A lot of personal injury lawyers are holding back because they want to see if things get better, number one. Number two, some personal injury firms are not even disputing. That's what they say. They're not even disputing. They're just going to let it all ride in tort. I don't know what that means. I was talking to someone about what we heard at another conference with one personal injury firm that said they were going to assign their rights to the tort defendant to go after the AB insurer. So I don't know how that will work, but we'll see.
Well, that's maybe a good segue to pile on the other big change that we experienced in the last year, which is the reduction in ABs across the board. And maybe David and then Richard, how is that affecting handling of tort matters, together with the changes in the LAT?
Well, just to start off with Jasmine's last point, no one has offered any of our clients any assignments. That's the good news, because I don't think any of our clients really want any assignments of any of the AB claims. I think one of the things I would say is that I've noticed a definite lack of accident benefit people showing up at mediations to try and resolve cases the way they once did. I can't say there's a unitary purpose behind all of this. It could be just straight coincidence, but there certainly seems to be a fair number of AB cases where the AB doesn't show up for whatever reason. And if it happens frequently enough, you start to wonder why. So some of that perhaps sliding over to the tort side may be happening, but the AB people, whether they're actually playing a part in that, I would doubt, but I've certainly seen some of that.
And Richard, how have the changes in the last year affected how you do your job?
The way my office works, I've got law clerks who are very adept at AB, and universally, they are pulling their hair out. They are enraged at the responses they're getting from the LAT. They find the adjudicators relatively unsympathetic. Because we don't have a cost implications, we've started to strategize that what we might do. I'll give you the analogy. We had a tort case that was on the cusp of trial. We were about 8 months out. The client's mother, who was the plaintiff, was very infirm. She was a 93-year-old who was completely self-sufficient, had a fall, it wasn't a motor vehicle case, and she needed some treatment, and because it wasn't AB, she couldn't get any, so we wrote to the plaintiff's insurer and we said, we're going to need X and Y and, make an advance payment, and they said no. And the son, who was 60, said, I'm going to have to sell the family home to pay for this. So we write to the plaintiff's insurer and we say, if you have defense insurer, if you don't give us an advance because we're not going to lose this case, we're going to go after you for punitives because the entire FLA strata of the case is going to lose their home so they can pay for something that you should have done because you've been stonewalling. Anyways, long and short of it was, they didn't come through with the money. The family had to sell the home. We ended up with an enormous case in court. How does that flip to the AB stuff? If I'm not getting it at the AB, I'm going to start looking at the tort insurer and I'm going to say, look, you guys, you can see from the liability, there are very few cases where there's a significant zero shot of a plaintiff losing. So it's going to be at worst contributory negligence. So I know you're going to be paying. I'm going to be squeezing you guys and saying, look, I can't deal with the LAT. They're saying no. We have no money coming. We're not getting fees for it. So 100% of our fees are going to be deducted from whenever they get. And if you don't start making advances, I'm going to add aggravated and punitive claims to my case. And we're starting to see that because the system at the LAT end is just so perverse. I can't disagree with anything Jasmine said, that it's changing. We're now looking at creative ways to get it from the tort side.
David, are you seeing more requests for advances?
We certainly see a lot of requests for advances. Some are in cases where there is a liability fight, a clear one, and some less so. In those cases, depending upon what the request is, generally what we're doing is we're asking for proof of what that situation is that may merit an advance payment. In other words, we don't just say, oh, you want 50 grand, our client's going to write a check. But if you have a case to make that says, here's what I want, here's why I want it, as an example, we need the following kinds of treatment, we'll say, well, send us those reports that say that, and send us what the cost is, and then we can actually consider it. But absent that, and when we're not getting that kind of information back, and it's just, send me 50,000.
Are you paying or just considering? Just
I
want to
think
keep this in mind for the future.
I think generally speaking, they're paying.
So
if you can prove that there is a need and you got reasonable medical evidence that's going to show what the need is, in your case, it's not a medical question necessarily. I wasn't sure what the point was, but yeah, they're paying. They don't always pay you as much, but plaintiffs ask for 50, they'll take 25.
The other piece that I think some plaintiffs will take 25.
I was
With an
just
advance,
slanting.
you're happy to have an advance.
And there are some plaintiffs, when you give them an advance of 50, will receive 25. That's another story.
No.
The present company excluded.
Yeah, of course. Where's that target?
The other reality is, and let's not kid ourselves, there is an entire generation of tort adjusters and tort defense counsel that have really never had to adjust a healthcare claim because the ABs paid it all. And so now, where this stuff is finding its way back into the tort world, you've got people that don't have the expertise and experience in figuring out what a healthcare claim is worth. And so I'm remarketing myself as a tort lawyer.
I was going to say something, and I can't remember what it was. Give me a second. Was it Wanda, did you say I was going to be the moderator of behavior or the moderator of the panel today? Was that you? No filter. Jasmine, I was going to ask you, in the squeeze on ABs, what, if any, impact is there of the increased availability and use of litigation loans? How does that factor into things?
I'm not a huge fan of litigation loans. I try to exhaust all avenues. CPP, EI, ODSP, OW. I try to go everywhere before my client has to take a loan. But if they can't get the funds and they need the cash, then yes, they need to get a loan. So I'll recommend a few companies. I have nothing to do with it because I don't love the fact that they have to do this, but I'll refer them to a few. And I can tell you that there is an increase, at least from my personal observation at my firm, which is all I can speak for. There's definitely an increase in the use of litigation loans because there's no money coming from AB to fund med rehab on serious claims where they're not CATs and there's not enough for med rehab. What are they supposed to do? It's going to take a few years for the tort action to settle, so they have no choice.
So back to maybe the process and the fact that we also have a question from the floor, which is exciting, that ties into something I wanted to ask about, which is loss of the right to sue and the significance of that. And I was going to ask you for an update on the constitutional challenge.
So in a minute or less, it was heard this week. Justice Belababa, who is a former professor of law, a pretty bright guy, he was supposed to hear this over 3 days this week, Tuesday, Wednesday, and Thursday. And 11:30 on Wednesday said, all right, you're done. We've heard everything I need to hear. I've read all the materials. I'm going to write this thing. So he cut through it like a warm knife through butter, understood all the issues, and we'll be writing a decision in the coming weeks. We expect something by end of June, perhaps early July. There were two primary issues dealt with. One of them was whether Joe Campisi, who was the applicant effectively, whether he had standing to bring the claim because he wasn't an accident victim. And so that was hotly contested by the Attorney General's office. And it seemed that Justice Belababa had some issues with that, even though there is some significant authority from the Supreme Court of Canada supporting that type of approach. Co-counsel on the case with Campisi was Rocco Galati, who similarly brought a case to the Supreme Court of Canada on his own, challenging the appointment of judges to the Supreme Court of Canada. So certainly that issue was not foreign to them, and they were able to address it. Curiously, the Insurance Bureau of Canada, who also had standing in this case as an intervener, did not argue the standing issue, and they made very clear to Justice Belababa that irrespective of the outcome of the standing question, they still wanted him to decide the pith and substance of the case, which is whether the constitutional challenge itself had merit. And so that was argued as well. It's very interesting when you're arguing these issues based upon the Constitution Act from 1867, which is what really this issue came down to. There weren't a whole lot of cars back then. And so, you're applying horse and carriage application literally to today's standards, and that issue was argued, and I don't know how it's going to turn out. We'll have to wait.
So opposite of change going forward, looking backwards, Jasmine, if you had a choice, as you did up until last year, to use FISCO or the courts for your accident benefits matter, what would you use?
I always use court, but I have a lot of friends that used FISCO. I liked running my AB with my tort. I like the discovery process. I like having a global mediation with everybody and trying to work it out. Definitely court.
And David, let's talk for a second, and then I'm going to move on to Richard about the loss of the right to sue, the importance of that right, the right to a trial by jury. Why does it matter?
Well, I guess I'll say it with great care. There's lots of people in this room who love juries, and there's a few who don't, but I think generally everyone loves them. One of the reasons, I think, is because there's been this belief that judges are a little out of touch with the community at large. And I would use as Exhibit A the prevalency over the last 3-4 years of most juries, when they hear soft tissue cases, to give plaintiffs very little money. I'm not saying that it was always demanded that the plaintiff get very little money, but I think juries, by and large, had decided, you know what, I know what soft tissue is, and I don't buy it, and I don't care what hired doctor you have that says it. It's a whiplash injury. I'm speculating. I don't know exactly what every jury thought. But judges had a greater tendency, and as we also saw in the threshold discussion, to fine for the plaintiff because they make an excuse. Oh, well, they maybe they didn't tell the truth about that, but that's not the pith and substance maybe of their case. So, by and large, I think that the juries have to some extent, I think, tried to bring the judiciary a different perspective to some of the judiciary to say, you know what, these are soft tissue cases. There was a purpose behind the legislation making a threshold. We're really trying to get rid of the smaller cases. And in that sense, I think it's done a great job. I love juries. I wouldn't want to have any defense case, well, maybe one or two, but any defense case without a jury. I don't think there's a better way to try a tort case in Ontario.
So Richard, I'm going to ask if you agree with David's remarks and if it makes a difference whether we're talking about a contested threshold case or a big bad case.
Part of what I will say agrees with David, which I find extraordinary to begin with. But first I want to thank your industry for invariably serving jury notices, because once you've served them, you almost never can get out of them. And as a plaintiff lawyer, with some exceptions, I love jury work. And I love it because, for the most part, I'm not up against these guys or guys like them. I'm up against other counsel, particularly in chronic pain cases, where the insurers have appointed, or the law firms have appointed, middle to junior level lawyers because they think it's a nonsense case and it's not going anywhere, and it's an uneven contest. And I'm also a great believer that one of the things that might come as a surprise to an audience like this is that, certainly for myself, and I know Jasmine's her, I don't take bad cases. I only take cases that I absolutely believe in. And if I absolutely believe in a case and then the client turns around and it turns out that they're conning me, I fire the client. I've done it. But for the most part, and I can count those on the fingers of one hand, if I believe in a case, it's because I think it's honest to God real. And if I think it's real, I think it's real because it's been proven to me. How? Because I've met with the clients, I've talked to their anecdotal evidence people. Who are they? The neighbors, the friends, the family doctor. Because there's very few cases where someone's prepared, logically, to throw their lives away for the sake of an if come, someday they're going to get a great jury decision. And so I'm a great believer, and so far, I haven't been proven wrong. When I think it's a good case and the other side says no, I take it to trial. And I think that, and I don't care if it's a chronic pain case or a brain injury case or a sore shoulder case. If it's worth it and I don't get the number that I want, I take it because I think that juries are invariably fair, which is not to say that when I walk into a courtroom, I don't carry a good liberal dose of Depends and kaopectate. I do every case. I never go in, and there's always, and I know it, at some point in the case, I'm going to be suicidal. I know it, because my favorite witness, and it happened on my favorite witness turns out to be Attila the Hun, and I'm going, what happened? Why did you do that? And I go home and I don't sleep for a week. Every case. But so far, at least, ultimately, the juries have come my way, and some of the times, I look at a jury notice because half the time I almost do this, but I always watch for the noting of the pleadings closed because there's a time limit and you can't serve a jury notice. So what I do is I just make bets in my office. I say, okay, would you, if you were the defense, would you want a jury trial on that one? No. And we have bets. 65%. I'll bet you $5 they're going to serve it, and they do. And I get to discoveries and I go, I got to ask you, did you do this intentionally? Because it's a gift. It's a gift. Because once you guys do it, it's sort of like I get my second chance. And I can't think of a single case today where I can only think of one. Somebody actually looked at the file and said, I don't want to go anywhere near a jury with this case. God bless, neither did I. And so for the first time in years, I've got a case where both sides had a realistic view of why they didn't want to have a jury, which will give you some indication of the appealability of my client. Right? It's sort of like my client will come across as Jack the Ripper, but on the other side, the guy looks like Jack the Ripper. It's sort of a fair game.
So you, Richard, had talked at the outset about the old days when people used to pick up the phone and files used to settle. Our clients talk a lot about cycle time and moving files from their referral to closure, whether that's resolution or determination, more quickly rather than more slowly. Are any of you seeing a return, whether it's with the lat in the timelines or any industry-type pressures? Are you seeing a return to people picking up the phone and trying to settle files? Or are you seeing the opposite? Maybe Jasmine.
You can't get me on the phone, actually, because I'm never at the office.
So it's your fault.
It's my fault. But there's email. And I'm going back to the first question that was asked. The biggest change I've seen in my career, and I have no idea what a telefax machine is, so whatever, sorry. So the biggest change in my career was the BlackBerry. And, you know, when I first started, there was the voice message that Jack Fireman would leave on my voicemail at night while I was home. And I would come into the office all excited as an articling student about what I was going to do that day. And then I would get that voice message, this incoherent, angry man message about what he wanted.
I've never heard a message like that.
What? Remember, I articled for Jack. Where do you think I learned it?
Yeah. So, yeah, he would want it first thing on his desk, and he would always, you know, stroll in at 10 a.m., which would give me a good hour, hour and a half. But somehow, whenever he would assign work the night before, he would show up early the next day and pass by my office and say, "Is it done yet?" Obviously, it was not done yet, and then he would go to his office. With the BlackBerry that came in over the next year, I made the stupid message of showing Jack how to email. So now he emails in all caps because he doesn't know how to turn it off, and I don't know. I'm like, is he yelling at me? Is he not? I don't know. Maybe a bit of both. Anyway, this brings me to current day. We're in real time. And I think as a plaintiff side personal injury lawyer, what a lot of you don't realize, because how would you, is that our clients are emailing us all the time. Every day, every night. I'm in the grocery store with my kids. They're fighting about what ice cream choice to get. I'm like sort of refereeing, sort of like, oh, let me check my messages. Oh, my client has been committed. Or, oh, my client didn't get their IRB check and they're losing their home because their landlord is at their doorstep. And I have to deal with those issues. So client management is huge right now for me. There's constant communication. And then it's, you know, everything is real time. So sometimes when adjusters are like, this is my second request for information and I have to keep apologizing, it's because I can barely balance because we are living in real time.
David, what about you? Are you seeing files move along more quickly to their conclusion? What are the things that you do?
I think one of the biggest surprises is that over the last 30 years, how long cases take now compared to how long they took before. I actually think 30 years ago, cases got to trial quicker. The trials didn't take as long. Now, if you go to trial, like the smallest thing is a week or two. It just seems to take forever. The one thing I do notice very recently is I find that the statements of claim are being issued earlier. You know, there used to be the day when they'd wait till, 2 years less a day, 2 years less a month if you really wanted to be careful. But nowadays, particularly with more significant injuries, statements of claim are issued routinely within the year. And people start moving on those cases.
Eric,
Much earlier.
Sorry, do you think that that's tied at all to the AB changes?
I don't know why they're doing it sooner. Maybe it's simply a recognition of the fact that it's going to take longer to get to trial. I would be curious to know what their rationale is. I don't think it's necessarily because of the AB changes.
Yeah, I don't see it as an AB change. The reality is, if I call the court today and I want to get my case in Toronto on, I I think I'm looking at 2019, and it's driving me crazy. And so what I'm doing is two things. First, I want to start it earlier so I can get discoveries earlier, so I can set it down earlier so that I'm running. And the second thing is, and I'm going to rue the day that I did this, but I've now started, I'll try to find any plausible excuse to start a case out of Toronto in a jurisdiction that's got short trial lists. And it's hard to find those. And I hesitate to think, I've got a couple of trials coming up where I'm going to be going to bed with bear skin to keep me from getting frostbite because it's that remote. But I did it intentionally because I just don't want to wait.
Barrie is not that far.
Right? And now you can see why we never settle cases together, because he's always insulting me.
And we've somehow managed to skirt around the whole settling of cases in this discussion altogether.
Well, let me
Do you have
be
something?
realistic about it. For me, it depends a lot. And I rarely settle cases at the adjuster level because I'm told by the adjuster early on that the limit of their jurisdiction is below a certain threshold and they've got to refer it out to counsel. And then I say, well, why don't we just do that? But every once in a while I'll get, and I had one recently, I had a pharmaceutical case where and it was an AB adjuster who was also doing this kind of work. And we got along, and I said, look, here's what I'm going to do. I'm going to tell you everything I've got. We were into it 6 weeks. I had a handle, unusual, because often you don't, but I had a handle on what the damages were because the client had spent 2 years futzing around with somewhere else. And they came in, and I put together a brief, and I sent it, and the adjuster phoned me up, and we had a realistic discussion, and he said, well, these numbers are crazy, and I told him why they weren't. And I ultimately persuaded them, and then he said, well, what about this issue? And I gave him some law. And we worked it out, and we settled a case that could have gone on for 4 years. We settled it in 2.5 months. It happens, but it's rare. In other instances, what I'm finding is, and I'm going to talk about this just at the end, but the posture, I'm a great believer in acknowledging penetrating glimpses into the obvious, which means you don't gameplay, so that if there's if that's a bottle, I don't want somebody looking at me with a serious face and saying, that is a cup. And I get that all the time. And it's not universal. And I don't know, I never know, because we don't, whether it's the adjuster, the claims manager, or the lawyer on the other side that's causing it. And sometimes, and I've had trials where I've got co-counsel on the defense side, and one of the counsel and I are having meetings saying, is it me, or is this a completely different case on that side of the table? Those are the parts that interfere. But if I've got educated counsel, okay, so, well, let's not go too far. But, okay, so David and I had a very complicated case with a whole bunch of parties. And David took a position that I thought in law was wrong. I had another characterization for it back then, but I'll let you. And David thought that I was wrong. And we couldn't settle, and it was a multi-million-dollar case. And I remember, so I went to him at the mediation, that was our second one, and I said, David, are you blowing smoke, or do you actually believe this position? He said, I absolutely believe it. I said, okay, then put your money where your mouth is. You bring a motion for summary judgment. We'll have that issue decided, and if I win, the case will likely settle, and if I don't, you're out of it and we're done. Most counsel less junior counsel would probably never agree with that. David, because he was telling me the truth. He said, that's fine. And so he did. Of course he lost. But the fact is, that would only have been accomplished by a guy who was confident enough to say, I'll tell you what I really think, and I really mean it. And same with Eric. And in other cases where I've had it, and we're talking million-dollar cases here, where there's a counsel, we've now had 3 cases together. Doesn't matter what time it is in the realm of the case. If he's on the case, I'll phone him up, we'll go and have dinner, we'll spend 3 hours talking about it, we'll go away, we'll have our own ranges, and we'll show each other what we really think it's worth. And in 3 out of 3 cases, we've settled. So it isn't a function of ABs, it's a function of realistic appraisal by realistic counsel, and every once in a while, you get for legitimate reasons, you get two completely different views of the case. But it's not because the other side doesn't know the case. It's because knowing what they know, because both sides, it requires mutual disclosure, they have different views of what's going to work. That's okay. And that's why I have jury trials, and that's why we have trials. But I don't see that a lot. So it's more a function, and it's not even to me a function of who the insurer is. To me, it's more a function of how realistic my opposing counsel is, with one caveat. There are a couple of companies that shall remain nameless where I have a candid discussion with the lawyer, and he, in a candid moment, or she in a candid moment, will say, yep. And then they'll come back and they'll say, and they're constrained, but they'll say, I'm sorry to tell you, but we're going to have to continue with this. It ain't their fault. But in most instances, they're absolute sphinxes. You can't read it, and they're not telling you. And I always ask. I say, come on, is it you or is it them? Never get an answer. Every once in a while, I get an answer. So that's more.
Does it make a difference?
To me?
Yeah, to know whether it's the counsel or whether it's the insurer. Does one get your juices flowing more?
No, but there is some element of, I mean, the fact is we're doing this, it's not coincidental that the four of us are on a stage, because we're in this business because it's part love of performance, and there's a certain element of gamesmanship and performance that I like, and that everybody does, or they wouldn't be doing this. And so if you really want to do something really bad, is piss me off. Because then you'll get all my attention. And if you think I'm anal in the ordinary course, which these guys will tell you I am, you piss me off, I am anal to the max.
So on that note, I'm going to cut you off. How's that? We are running out of time, which is unfortunate for a number of reasons, because this is interesting. And I also wanted a little more time to show off the fact that I bought shoes in team colors, and I feel that deserves some attention. But we have a couple of questions from the floor that I'm going to throw out to whomever. And then I wanted to leave our guests with a quick last word. You don't often have an opportunity to address this many people who you interface with indirectly day in and day out in person. And so I'll give each of you a last word after the two questions that I do have. One, why, let me make sure I get this right. Why are top personal injury lawyers holding back in terms of putting cases into the lot, allowing perhaps eager but perhaps less qualified paralegals to flood the system? Does that not risk getting a bunch of bad decisions? You don't know.
It's me?
No.
It's whoever's.
Are you a plaintiff lawyer?
No, ask Jasmine.
Oh, okay. The problem is time, I think. Time and money are the two reasons. First of all, the timelines are seriously killing us. Like the unilateral scheduling, the timelines of it needs to be done next week, next month, and we're supposed to have everything in order when we already have a full schedule is very difficult, and we want to do the best we can do for our clients. We can't do the best if we have other clients that we already have things scheduled for that were scheduled, 8 months, 10 months before. I can't push that. The second thing, again, it's money. It's a lot of time, a lot of effort, and we're not getting paid for that. And as much as, I joke about the pro bono thing, I want to help my clients. I really do, and I'm not just saying that. When they come to me, I want to do everything I can do for them. And I wish it wasn't about money, but unfortunately, I can't run my firm if I'm not getting paid on every claim. So I think those are the two main reasons.
So I will give a slightly different take. It's a much more jaded and pessimistic one, which is more up my alley. I can tell you that the good plaintiff lawyers are good for a reason. It's because they understand that to win a case, they need evidence, and in order to proceed with a claim in a much more expedited basis, they need time to gather that evidence. And so they are waiting to do that appropriately, whereas the lesser lights with the lesser claims are not as sophisticated. They have been rewarded in the past at Fisco with cash settlements on a nuisance basis, on really questionable claims by a number of insurers that operate in the model of, let's be economically realistic about these cases instead of making them prove them. So they had been operating under the premise that worked, and it continued to work. They were conditioned appropriately, and they weren't astute enough to see that there was a big change coming at the LAT. They continued with what was working for them at Fisco and learned, or didn't learn, quickly that it wasn't going to work in the LAT, because if they don't have evidence, they aren't going to get any money. There isn't as much of an economic inducement to settle these cases for insurers in the LAT, where there are no cost consequences, where there isn't a transparent filing fee that is being charged. So all of those reasons are no longer there, and insurers were much more emboldened to take cases through to the LAT. It wasn't a long investment of time or money to do so, and they did, and they won because the representatives of the claimants had their pants to their ankles when they went to the hearing. And you're not going to win very many cases with your pants to your ankles, generally speaking.
You've always been good with the visuals. Thank you for that. So the next question I'm not going to ask because we could be here all day, but it's from Kate's table, and it was basically about the life expectancy of the LAT, considering the constitutional challenge and the possible outcome of that, as well as the likelihood that the court may take a bit of an oversight role with judicial review, some of these cases we're hearing about. So we're not going to answer that, but I'm asking it, and I'm telling whoever asked the question, Eric could go on about this for days, and he'd love to, so get together at the cocktail hour. And now for the last word, Eric having taken the second last word, each of our guests, what do you want to tell them?
First, thank you so much for inviting me. It is really a great experience for me and a pleasure to sit in front of you and to be able to meet some of you when we're not sitting up here, because I never have that opportunity to chat with all of you, so thank you for having me. The one thing that I just want to leave with you is that you may not realize, maybe you realize, but what you say to my clients, how you behave when my clients are watching, it impacts them. Your decisions on your files, for my clients, it impacts them for life. You may just be chatting casually, they hear you. You might, say something, it stays with them. When I'm in a mediation environment, I can't tell you how many times it started off terribly when an adjuster is overheard by my client, and then my client thinks, no one believes them or no one likes them or whatever, and that sets the tone. And there's an adjuster in this room who I had a mediation with a couple of weeks ago, and she did one of the best things that she could have done for my client. My client was involved in a football injury and had some fractured vertebrae, and the parents were really upset. Liability was very difficult, but in any event, my clients were not happy people, and I didn't know what was going to happen that day, and that adjuster took the time in the mediation environment to say, "I'm sorry this happened." And the mediation settled, like the file settled. It shocked me, but that's all they needed to hear, that someone actually cared about them. So I just wanted to leave that with you. Thank you.
Richard?
I'll pick up on that. It's a human process. And I'm often, maybe I'm jaded, but every once in a while, I'll find myself surprised because, and thankfully it's less than it used to be, that the adjuster, it's much what Jasmine said, the adjuster across the table, or the case manager, or whoever happens to be there with counsel, starts off by saying, "We're really sorry that we had to meet under these circumstances, and we all have a job to do, but we're very sympathetic." And it just cuts a lot of the tension in the room. It's just a human process, and it's much appreciated. The other one is that I want to thank you as an industry, apart from the fact that I'm here and this is an interesting venue for us, because in a lot of years of practicing, almost invariably, and this goes more to the managers and the vice presidents, you inevitably present offers that present no threat whatsoever of any adverse consequences to any of us on the plaintiff side. Certainly that's my experience. And what that means is that if I don't beat the offer, there's huge cost consequences, just like the other way around. I can honestly say I have never been in a trial, maybe one case, where I've been confronted with an offer that I thought was reasonable and that I had a chance of losing. And I can't tell you that if you guys get more realistic, or the instructions that you're getting from up high are more realistic about real numbers, then a lot more cases are going to resolve a lot quicker. But I wanted to thank you, because if you take a look, the theme when you heard Jennifer talking about my CV, I focus as much on costs as I do on damages. Why? Because the more I get from you guys for costs, the less my clients pay, and they love it and I love it. And so what I do is I play the offers game, and I'm forever astonished at the unrealistic views that the insurance industry generally, in all the cases that I've had over many years, to the extent to which they underestimate what's going on in the real world. And so, maybe, and I don't know why that is, whether it emanates from counsel or it emanates from, because nobody ever tells me, but it's a blessing. Because if you guys learn to play the offer game better, and I thought, and I told them I wasn't going to tell you this because I don't really want you to change. I really don't. But maybe a whole lot of other cases will get solved and resolved on much more reasonable bases. And that's the most stunning. And I tell the lawyers on the other side of cases that I'm on, I just thank you. You've given me a gift. I usually tell them 1 minute after the trial starts so they can't change it.
Thank you, and thank all of you. That was the last word, although I see Eric wants to keep talking, and he can't. It's just he cannot do that.
I just wanted to...
Oh, but David can.
It's him.
It's me, right. So I just wanted to sort of conclude by saying something about what I think is great for every one of us to try and remember. Sorry, excuse me, is try not to treat every case you have the same way. A lot of us have been put in the position of being commoditized. Everyone's heard that word in here. The files are commodities. They're all the same. We're going to treat them all the same way. My suggestion is that you be creative on every file you have to see how you might resolve the claim quickly and efficiently. Because if you remember what creativity really is, it's just, in a sense, the opposite side of the commodity spectrum. Commodity, where everything gets treated the same, and creativity, where things are changing. And obviously I use the word change because you're being creative, because you're trying to find a better way to get the case resolved. If we can all do that, I think we'll all be better off. Thanks.
And you actually presaged my last sentence, which is there's so much more to say. So there are about a dozen things that we could have picked up on from this conversation, and it's always good to finish a panel with a whole lot more that we could have discussed. So thank you. We are struggling with the clock today. We ended up with a little break after lunch that we hadn't necessarily expected. So if we can keep this break pretty short, basically just 2 minutes. Ms. Kawaguchi says 2 minutes. So we're just going to get our speakers mic'd and get on with the next panel. Thank you.